Sarah Boone's fans have filed a motion to dismiss the case. If you need a good laugh today, take a look at this. Hey everybody, it's Chris from Guilty Words, where we unravel crime one word at a time. Just when I thought the Sarah Boone case couldn't get any wackier, it does. But this time it's not Sarah. It's a couple of her fans from California who have filed a motion to dismiss the case. And it is wrong on so many levels. Let's take a look at this nonsense together. So let's begin with the actual physical paperwork that was filed, because just a quick glance is enough to tell us that this was not filed by a lawyer. First of all, it was mailed to the court clerk, and the couple that mailed it put their real names and return address in the corner, so it wasn't Sarah Boone mailing it. That's a very unwise thing to do in this day and age. I've cropped it off, but if they had done their due diligence and really looked at the docket, they would realize everything mailed in has the envelope scanned in as well. In addition, the motion itself claims that Sarah Boone is the attorney filing the motion. Doesn't look like it. And the wording in the motion that we'll get into in more detail in a minute proves that it's clearly not written by a lawyer. But it may have been written by people that went to the Sarah Boone School of Law, because it includes the Bill of Rights, one of Sarah's favorites. And interestingly enough, they don't seem to like Roman numerals because they whited them out and put in standard numeration, except up at the top where they left the 1 through 10 in Roman numerals. So certainly not the type of paperwork that a licensed lawyer would submit. Also, I believe licensed lawyers have a way to electronically submit their paperwork to the court. They don't have to mail it to the poor court clerk who has much better things to do with her time. Let's begin by addressing the point of the motion. It claims that Sarah's right to a speedy trial has been violated. No, it hasn't. If they'd done their due diligence and looked in the court records, they would see that, because on November 2nd of 2020, Sarah waived her right to a speedy trial. There wasn't an official piece of paper that went with that. It was said in the court and recorded in the court minutes. So no, Sarah hasn't had her right to a speedy trial violated. In addition, as anybody who's followed this case closely knows, the last thing in the world Sarah seems to want is a speedy trial. But there's more to this motion. It looks more and more like these people went to the Sarah Boone School of Law. In addition to adding the Bill of Rights as if lawyers don't know it, they have these other two details that are completely unrelated to their claim that Sarah did not get a speedy trial. The first is restraints were placed on Sarah on February 25th, 2020, her arrest and booking. I don't know what the point of putting that in is, because people are handcuffed when they're arrested or restrained, because generally they're not in a very good mood. And so for the safety of the people arresting them or to prevent them from fleeing, they're put in restraints. It is not a form of torture under the U.S. Constitution. The other piece they put in was once in jeopardy on 4/13/2020 arraignment. I went and I looked at what happened on 4/13/2020, and that's when Sarah entered her plea of not guilty with her attorney. She waived her arraignment. There's a note here that it was an in-jail arraignment. I don't see any jeopardy there. She's saying she's not guilty and she wants to have a trial. Where's the jeopardy? But there's even more. Let's look at another piece of this crazy motion. It says, motion to dismiss the case in charge with a comma, like charges, but I don't know why there's a comma other than it's a typo and they don't edit well. Or maybe they thought they needed an apostrophe, but the apostrophe goes up at the top between the E and the S, and there shouldn't be an apostrophe anyway. Whatever. And then they say, motion to dismiss case charges with constitutional authorities. What does that mean? With constitutional authorities, does that mean that they're using the authority of the Constitution, i.e. the Bill of Rights, as the reason for dismissing? I'm not sure that goes here. I'm not a lawyer, but I think that would be in the motion itself, and they do include it, plus the printout of the Bill of Rights? Or are they saying that they want to dismiss it with the constitutional authorities, like the court? I don't know. Like with many of the things Sarah herself writes, who knows? Let's look at the actual wording of the meat of the motion. It does imitate Sarah in some ways. First, it has her typical word salad to it. The things that make you go, wait, I have to read that 6 times to figure out what it means. It also uses her penchant for uppercase letters for emphasis. It insults lawyers the way she does. And it either misuses or outright creates words. Authority, the Constitution of the U.S. Amendment 6, specifically the right to a speedy trial, has been violated. The state of Florida has not met the requirements or proven good cause of delays. Ineffective substandard state-provided attorneys should have made this request long ago, proving this as a fact. The word authority is off here. I can't quite figure out the right substitute, but to say authority, the Constitution of the U.S. is not how you would argue the case law for something like this. Next, these people go on to say the state of Florida has not met the requirements or proven good cause of delays. Well, they don't have to because she waived her right to a speedy trial. So that's moot, but proven good cause of delays is definitely some awkward wording there. And my favorite, ineffective substandard state-provided attorneys should have made this request long ago, proving this is a fact. Ineffective is not a real word. I think they mean ineffective. Substandard state-provided attorneys, public defenders, or lawyers that were provided by the court, were substandard. They didn't help her because we know more than they do, and they didn't file this. Should have made this request long ago, proving this is a fact. Wait, what proves what as a fact? What does this mean? Does it prove that they're substandard? Does it prove that her constitutional right to a speedy trial has been violated? What is this? And proving this is a fact. There's no real proof here. Like Sarah, who says, in my opinion, and thinks that's proof, apparently this is another example of just say it so and it's so. And it doesn't work that way in court. So what conclusions can we draw about this? Well, it's a nonsense motion. I'm torn about how I feel about the people who wrote it. One part of me is empathetic. If they genuinely feel that justice has not been done for Sarah because of the speedy trial and they want to help her, I appreciate their thoughts, but it's problematic on a lot of levels. If they're attention seekers, well, they may get some attention they don't want. I certainly hope that people on the internet don't start personally attacking them because their information is now out there. But one of my biggest questions is Judge Cranick's reaction. I want to know if that poor man spit his coffee out the way I did when I first read this, because it's just so unbelievable. So we may never know, but as if Judge Cranick doesn't have enough to deal with, here comes this. I hope this has given you a bit of a smile today. And if you've enjoyed the content and you're not subscribed, please, I'd be honored to have your subscription and give it a thumbs up so the video gets out to others as well. As always, thank you for spending your time with me today. I really appreciate it. And until we meet in the next video, please use your words wisely and well. Take care.